Appeals today. This is our second case. The panel members include, to my left, Mr. Henry Green, who joined the court in 1993, and to my right is Mr. Michael Boozer, who joined the court in 2005. My name is Kim R. Schroeder. I joined the court in 2013. I am the presiding judge, which basically means my job is to be the timekeeper for the arguments that I have set for 15 minutes apiece. The case on for hearing this morning is State of Kansas versus Baltazar Ruiz, case number 121,060. In this case, out of Finney County, Kansas, Mr. Ruiz was charged with driving under the influence and possession of cocaine. He alleges error was committed by the judicial comment. Error was committed by the trial court during at the time the state rested its case. And he also argues that reversal is required because the state used an improper jury instruction on one of the elements of cocaine possession. With that, Mr. Kearns represents the appellant, Mr. Ruiz, so he can go first. And if you would like to give a few more additional facts than I have for the benefit of anyone who is watching, you are welcome to take a few minutes and I won't count that against you. The other issue I have is, do you wish to reserve any rebuttal time?
May it please the court, Your Honor. Yes, I'd like to reserve 5 minutes if that's all right.
That's your time. Thank you.
Yeah, everybody froze up on me, so I hope I said 5 minutes and you heard me.
I did. 10 and 5.
Hello? Andy? Okay.
You appear to be freezing up.
Thank you. Yeah, I saw that myself, other than it was working perfect earlier, Your Honors. I apologize.
Well, that's part of the issue with technology. It doesn't always work right.
Andy! Can everybody hear me, and should I proceed?
Yeah. I can hear you, and we'll proceed as best we can.
All right, well, my apologies to the court. This is a case about a man who got arrested on a DUI during the course of a search at the jail. The officer found his wallet. Inside the wallet, up inside a dollar bill, they found a baggie with 0.02 grams, a very, very small amount. Some might even call that residue of cocaine. As the court noted, there's three issues really. The first is, were the court's statements improper? I'd argue that they were, because what we have to focus on initially is what is a jury's function. I'd argue the jury's function is to evaluate the evidence for the existence of reasonable doubt, not weighing of who's got the stronger case, like that might apply in a civil suit. Here we have a comment, and our initial issue was whether the district court erred in basically making a comment that what the defense's feelings were and the defense's feelings on how strong their case was. And we argued that that's improper. It puts a burden of proof on the defense as opposed to keeping it on the prosecution. So that's our first issue, is did the court err with regard to that statement? And I'm sorry I have to keep checking in because I'm seeing a few just frozen screens. I want to make sure.
You're coming across okay on mine.
Okay. Thank you. Then the second issue we have, Your Honors, is whether or not my client's set of jury instructions were sufficient, because what we have is a kind of a combolage of two different theories, well, three really: knowledge, intent, and then there's also a reference to recklessness. And our position is that there's no such thing as recklessly possessing cocaine. I know that there was the Chapman case that was attached to the state's case, but I believe that has since been modified, if you will. And in fairness to my colleague, William, with apologies, I don't know why I wait till the morning of, but I did run a search this morning and I did find another case, which with my paralegal being out in quarantine, I didn't do the letter that I was asked to do, but it is State versus Harris at 379 P 3rd 1145, which I would argue makes it pretty clear that
Can
right
you
now in
repeat that site
Kansas,
again?
there's no such thing as recklessly.
Mr. Kearns, can you repeat that site?
State versus I'm sorry. Yes. State. Oh, sorry, I cited the Hanks case and I meant to say the Harris one. State versus Harris, 459 P 3rd 837 2020. It was right about the third week of the pandemic it came out and I just missed it. So, but I would argue that it basically stands for the proposition that right now we don't have reckless possession of cocaine.
What was it
We
said
have
again, Mr.
intentional,
Kearns?
we have knowledgeable, but what we don't have.
Counsel, did you have a
I'm sorry,
question?
William.
Yeah, what was that
Uh,
site again? I'm sorry, just so I can pull it up real quick and look at it.
Here. 459 P 3rd 837, March 27th of this year.
Awesome, thank you.
Thank you. And apologize for not getting the letter out to the court and to my colleague on that, but I frankly just found it this morning. Should have been on the ball a little bit better. But in any event, that's our second issue, Your Honor, is whether or not the court's instructions taken as a whole add to the error in this case. And then thirdly, I argue even if one or the first one or the second one aren't a problem, in combination of the two of them together, the cumulative error worked to deny Mr. Ruiz a fair trial. I'm seeing a frozen face, so am I still with everybody?
You are.
Your Honor, our brief is premised upon really what should a jury be told by the court, and it's well established that the juries take the statements of the judge a lot more, should I say, to heart, and the behaviors of the judges and the winks of the judges and the nods of the judges, are important. And certainly if a prosecutor is prohibited from saying it, the court ought to be prohibited from saying it. And so our brief describes a few incidences where the prosecution has been, told you don't comment on things like that. The specific comment at issue related to defense strategy. In fact, the exact court's comments was because the defense feels that their case is strong enough at this point, but it also emphasized that the defense certainly had the right, which is a true statement, but it also emphasized and inferred that there was some sort of burden shifting going on. You have certainly had the right to testify, folks. He certainly had the right to bring in all these people. He chose not to do that.
Excuse me for a second.
Because he felt their case was strong. Yeah.
Excuse me for a second. Wasn't a court, didn't it? A court made the statement because then basically the defense, didn't they say, if this is all the state has, the defense rests, and then you have the trial court going explaining to the jury that basically, evidently, Mr. Ruiz felt his case was strong enough, and therefore he wasn't going to put on any evidence. But wasn't the trial court trying to explain to the jury that this is what we're going to stop now because the defense does not want to introduce any evidence, and since the defense doesn't want to do that, it wasn't a trial court explaining to the jury that this is basically it's going to end right now, and we're going to deal with instructions.
I know, Your Honor, that I know, Judge Green, that you're exactly right, that was in the transcript insofar as that was the context. The state said they're done. The defense lawyer said, well, if that's all they have, we're done. Interestingly enough, the court didn't just talk about the feelings of the defense side, but also talked about the feelings of the prosecution side and how they felt their case was strong enough without any kind of rebuttal. And I guess I would go back to, I don't think the court knew what the feelings of either side are, and the court shouldn't be talking about feelings or strategies of either one. But as far as how it flowed, yes, you're right. He said, if that's all they have, we rest as well. But I don't know why the court then would have to say, well, they had the right to bring in all the witnesses they wanted, that he had the right to testify if he wanted, he chose not to. We believe that was an undue inference of burden shifting and something that a prosecutor wouldn't be allowed to say.
Okay, let's say we agree with you, and this was air when the trial court made that comment. Tell me, what would you say as far as, would it be harmless?
Well, obviously, no, it wouldn't. I'd argue it's not harmless because it's something that goes to a constitutional event, something that's well established and something that's been around since the beginning of our system, which is, does a defendant have any burden? Does he have any burden to bring in a single witness? Does he have any burden to testify? And I understand that there were jury instructions that basically said the opposite of the inference. So what we have is kind of like we had on the second issue I'll get to in a minute. But on the one hand, we have, on the other hand, we have this. On the one hand, they could have called in any witness they wanted, and he could have testified if he wanted to. But then again, he's not really required to in the written instructions. On the second issue we have with regard to recklessness, on the one hand, the recklessness is enough. He could have just forgot about the residue in the dollar bill, and we can still convict him. And then a separate instruction that doesn't include recklessness definition.
You mentioned instruction, okay? And I'm still dealing with this improper comment that the judge made, and I'm saying, yes, if we say it's error, but didn't you ask for instruction that the defendant has a right to remain silent, and actually got this instruction to the jury? Has a constitutional right not to testify, and that instruction was given to the jury. Does that do, as far as the harmless, does that do something as far as saying it's not as egregious as what the trial court did as far as making this comment improperly, to say it's improperly, about him deciding not to testify?
Yeah, and I understand the court's question, and I point out that if it's harmless, it's a state's duty to prove that it's harmless, not my duty to prove it's not. Under State versus Ward that I cited also in my brief, it's kind of like we're back again to whose burden is it? And
it's burden, you're correct. It shifts to the state if we're doing a harmless, constitutional harmless, and they have to show beyond a reasonable doubt that this error would not change the result here. And the state argues that the evidence here was overwhelming. What would you say to that?
Well, I would say that's been in every single brief I've ever read when it comments about.
So it's nothing new.
No, it's nothing new, Your Honor. I mean, I understand the state does argue that quite a bit, but I'll give them, the reality is it's in his wallet. So, and I understand that this latest case, which was partly good for me and partly not so good for me, raises that issue as well. And perhaps that's why you're raising it. Why I would argue it is that we have a substance that clearly wasn't in plain view. It was so microscopic, and I think that's what we have to focus on here is 0.02 less than a gram. And that's why the recklessness issue is so important too, is because let's say if Baltazar party 3 weeks ago and he does his whole gram of cocaine and there's a little left in his wallet, but he doesn't want to throw away his dollar bill, he's not intentionally possessing cocaine anymore. He used it 3 weeks earlier, but he didn't want to throw away his dollar. We have studies that show that there's cocaine on massive amounts of currency here. Is that reckless now because we have that in our pockets? I would argue, in fact, my very first jury trial, though, ever was in 1991, Claudel Elias, and he had cocaine in his pocket. And the jury acquitted. But there was a whole lot of evidence showing that his little brother was selling fake cocaine and he was trying to protect his little brother, and it ended up being real. But I think it's easy in 2020 hindsight to say it's overwhelming. The state tries to make it look like he confessed to it being there. I think if you study with the actual record of what was said and what wasn't said, you have a Mr. Ruiz, whose primary language is Spanish, being talked about whether after it's found, opened, and shown to him, asked, is that drugs? And the officer said that our client said, yes. I'm not clear whether that was in Spanish or whether that was in English. And I'm not clear whether he's talking about the stuff that just got showed by the cop or the stuff that was in his wallet and folded up inside the dollar bill. So I think that's an issue for a jury to determine. And I would argue it's not harmless, certainly not proven to be harmless beyond a reasonable doubt.
Counsel, I've allowed you to go over your time a little bit here, so I'll give you a minute to wrap up.
So, Your Honor, and even if the court finds, and I haven't gotten to talk so much about the second element, but I would just say that the Harris case found, I think, clears that up. That just came out in March. I'd ask that the court, my colleague, read that one. And then it goes down to, even if one alone isn't enough, that the combination of these two should be. And I thank the court. And I apologize for whatever technical errors my office is causing on this. I don't know.
No, you've come through loud and clear on this part since we started, so thank you. Counsel for the state.
Good morning, Your Honors. Good morning, Mr. Kearns. Thank you. Regarding the first issue.
You might make an announcement of your name.
Oh, yes, sir. May it please the court, the state of Kansas appellee appears by William Votipka.
Thank you. You may proceed.
Thank you, Judge. And I think Judge Green hit it on the head when he was talking about regarding the first issue and judicial comment error. Based on the statements that were made by the judge, those statements there's an issue, one, of whether it was even error, specifically because Griffin versus California held that there was a forbidding of commenting by the prosecution on the accused silence or instructions by the court that such silence is evidence of guilt. I think at the core, Griffin is meant to prevent commentary that either the accused silence or instructions is evidence of guilt. I think Judge Green was right inquiring and speaking regarding the issue that statements by the judge were merely a roadmap or stating of the posture of the case as it was occurring. And what's extremely important is that they were made early on, prior to convening for jury instructions. After that, the jurors were given or jurors were brought back out and all the jury instructions were read, and consistent with the inquiry by Judge Green. Specifically, jury instruction number 5 dealt with the defendant's constitutional right to trial, and that as a result, he may not be compelled, and that there's no inferences to be taken by that. So, one, I'm not sure there really was an error by the statements by the judge, and it was merely summary and stating the posture of the case. And two, even if it was error, it was harmless because I think it's clear beyond a reasonable doubt the district court's comments did not affect the outcome of the trial, especially in light of the entire record. And there's a number of reasons for that, because the comments were brief, they were made in passing, and they really provided, and when were provided within the context of laying out the posture of the jury trial. Moreover, the comments were attenuated by the inference and were stated specifically that the defense wasn't going to call any witnesses because they felt, or at least it was the judge's feeling of the statement, that the state's case was weak. If anybody was prejudiced or potentially affected by these statements, it would be the state. But I think that goes to the issue of prejudice, and further, in addition to the statements and the fact that they weren't made in any way, shape, or form to reflect negatively on the defendant or shift the burden, especially too, because after the jury instruction break, they came out and the court came out and gave jury instructions, which specifically properly instructed the jurors on the consideration of evidence, presumption of innocence, burden of proof, and constitutional right not to testify, in which no inference of guilt may be made upon Mr. Ruiz's failure to testify. And then going to issue number 2 regarding the jury instruction error. First and foremost, I think I'd be remiss if I don't address the issue of invited error. This was an instance where parties talked about the instructions. At one point, the court asked if there's any objections or requests as it relates to the instructions as proposed. Unfortunately, most of the discussions and conversations and agreement regarding jury instructions happened off the record. Really, the only statements regarding the potential on the record agreement would have been when the court asked Mr. Ruiz whether or not, Mr. Ruiz's attorney, whether or not there was any objections or requests, and I quote, no objection, judge, and no additions, end quote. So even if that's enough for invited error, clearly there was no objection, and as a result, the appellant's going to have to show clear error. And looking at this case and the facts, I think that the Chapman case that was cited by the state, and I haven't had a chance to go all the way through the Harris case, although looking at it quickly, it looks like the court found that they were convinced that the jury would not have reached a different conclusion absent the mention of recklessly, and that they found that it was harmless. And that may actually get to the third layer of inquiry when we're talking about the jury instruction issue. But I think that the instructions as given in Mr. Ruiz's case was legally appropriate and was factually appropriate, especially when you get to, or even if you're discussing the issue of recklessly possessing a controlled substance. When you look at the Chapman case, and that's a case in which David Bryan Chapman, Westlaw, or 219, Westlaw 2709799 that I included in the brief, that was an instance where the court found that someone could recklessly possess a controlled substance. And I think even Mr. Kearns kind of got to that issue, especially when he's talking about the idea that Mr. Ruiz may have had a quantity of cocaine. It was in a dollar bill. He used that cocaine earlier in the week, but he still had cocaine in his wallet, in his dollar bill. And under that scenario, that would seem factually appropriate regarding someone potentially recklessly possessing marijuana. In fact, and my brief goes through a lot of conversation about mens rea and actus reus and an attempt to reconcile the differences between the actual elements where there is no culpable mental state and the definition that has no or knowingly. And I think that you can reconcile that from the standpoint that in order to possess the controlled substance, you have to do it with some quantum of knowledge that prevents people who and specifically even regarding Mr. Kearns's first jury trial, that he doesn't take or someone doesn't put drugs and you're absolutely liable because it's a strict liability potential conviction. But it's a situation where you have to, under the facts or the act, know that you have it. But then since there is no culpable mental state, I think it's reasonable you could reconcile that someone may intentionally, knowingly, or recklessly possess a controlled substance. So kind of wrap it up, and I'd be more than happy to take any questions. I don't think the state, or not, I don't think the appellant, because they have to show clear error, if there was an instruction error, they failed to demonstrate the necessary prejudice that a jury would have reached a different verdict without error. And I understand Mr. Kearns's statement or position that he always hears that every case is strong. But I feel like this was an especially strong case from the standpoint that Mr. Ruiz was convicted of, or I'm sorry, arrested for DUI. When he was at the jail, they found a quantity of cocaine in his wallet. And It wasn't, we're not talking residue on a pipe. It was an amount that was in a dollar bill. And when asked whether it was drugs, he said, yes. I know that Mr. Kearns has brought up a number of potential other issues regarding the facts as they would be, but I don't think that's relevant or to be considered. I think the issue is, and you look at how strong the case was, that I don't think the jury would have reached a different verdict if, in fact, or even if there was an instruction error. And then just lastly, based on the claimed errors and the fact that I don't think there was an error, that there was prejudice, there is no cumulative error in this case.
Is that all?
Yes, thank you.
Okay, I want to make clear, I'm not trying to rush you. I just want to make clear. Well, with that, Mr. Kearns, I'll give you your opportunity for rebuttal.
May it please the court, Judge Schroeder, and I'll be brief. As to the issue of invited error, part of the problem is we don't have a record of the conference or the jury meeting conference. The only thing we have is no objection. And it's a different story. Invited error addresses a situation of when I go before a judge and I say, Judge, I'd really like you to file this jury instruction. I want it. And then on appeal, it gets argued that it was a bad instruction. We're not talking about that here. We're talking about a set of prepared ones by the judge where he stands up and says, no objection. So the facts are distinguished from the invited error doctrine in this particular case. The Chapman case that my colleague discusses a little bit, methamphetamine that got in a pipe that got tested, and the issue was whether the young man thought it was marijuana or methamphetamine, and they found that that was enough. What was the issue in that Chapman case? On appeal, there was only one issue raised, and that issue was, is there enough evidence to prove recklessness? So it was never even an issue on appeal as to whether there was such a thing as reckless possession, which our recent case in March shows that there wasn't. The only thing brought before 2 out of the 3 members here was, hey, looking at this set of facts, is there enough of these facts to prove what the state argued at the time? And the Court of Appeals said yes. That's clearly distinguishable from what I'm arguing in this particular case with regard to the instructions and with regard to their sufficiency and with regard to the combination of errors here. Thank you, Your Honor.
Thank you, counsel. With that, this session of the Kansas Court of Appeals will be concluded. We will do our best to have a decision out within 60 days, which is our practice. And counsel, thank you for your participation today. Everybody have a great day. We are adjourned.
Thank you.
Thank you.